Good day, Crime Talk aficionados. We have a great show for you to start the month of March. And you know what? Maybe I was wrong about parents being held criminally responsible for their children's actions. Because there's a deeply concerning case in Miami in which two boys, aged 12 and 13, have been charged as an adult. Wait till you hear what they did. In the Nancy Guthrie case, the FBI has made some significant moves that suggest, a major shift in the investigation. And no reward has been claimed. The federal prosecutors in the Luigi Mangione matter, well, they're not going to appeal the ruling that bars the death penalty. A new motion filed in the case of Suzanne Morphew. That's right. Her daughters would like to have the remains returned. And we also report on the trial of the former Louisiana mayor, Misty Roberts, who stands charged with sexual relationship involving her son's 16-year-old friend. And how about that Jacksonville sheriff deputy accused of falsifying overtime reports because he was visiting his romantic partner, who just happened to be his boss? We've got This Day in Legal History, our legal quote of the day, and our dumb criminal. That's right. More food crime today, ladies and gentlemen. You'll want to wait to stick around for this one. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, and hit that bell so that you receive notifications of when we go live or put up new content. So also, before we get started, let me remind you, go to crimetalksearch.com where you can sign up for a background subscription service today. When you do, you can do as many background searches as you want. If you want to do one, cancel, you can do that. If you want to keep it every month and do a background search, maybe you got some armchair investigation to do yourself, I understand. When you sign up, you will be able to literally type in a person's name, anyone here in the United States, have the report prepared while you wait. It is then emailed to you in final form, and it can even be updated. And you're going to get all types of information: phone numbers, email addresses, social media presence, property that's owned, bankruptcies, divorces, criminal history, and are they on one of those sex offender registries? Yes. So whether you are being a detective or whether you just want to know who's coming into your life or whether they should stay in your life, go to crimetalksearch.com. You're going to be happy that you did. All right, ladies and gentlemen, it is already March 2nd, 2026. Where has the time gone? All right, let's go ahead and open the record for today. First, like I said in the intro, perhaps I was maybe wrong about charging adults for the conduct of their children. Right? We were talking about the case. We've had several of them over the years. One going on, obviously, in Georgia. We had the case in Michigan, where, of course, it was a shooting. Now, shootings apparently are much more results-oriented when it comes to getting convictions of parents. But wait until you hear this particular case, all right? In a case that's obviously provoked some widespread condemnation, police in Miami have charged two boys, aged 12 and 13, as adults for the alleged violent sexual assault on a 12-year-old girl. Now, according to court records cited in public reports, on February 27th of this year, Nelson Nunez and Josiah Jones, 13 and 12 respectively, allegedly approached the victim, forcibly dragged her into a garden area, pinned her down, and subjected her to an assault of the sexual nature lasting approximately 30 minutes. During the incident, one of the boys reportedly placed rocks in the girl's mouth to silence her cries of, "No, no, stop, stop, it hurts." The assault reportedly ceased when the victim's father called her name, at which point the boys and another witness fled. Now, the decision to charge the minors as adults reflects obviously the severity of the alleged conduct. And there's been a lot of people commenting, including strong calls for the maximum penalties and parental accountability. Obviously, the case is in its early judicial stages with no further procedural details released as of the time that we are bringing you this report, ladies and gentlemen. So, let's see if the bandwagon of charging parents of juveniles when it comes to gun cases will continue when it comes to crimes of violence of this nature. And does it matter the race or ethnicity of the defendants, right? Because most of the school shootings are predominantly white kids. Are they not? At least what we've seen so far. Will they still do the same for these 12 and 13-year-olds and maybe their parents? I mean, clearly one could say maybe these parents shouldn't get the Mother and Father of the Year award, and these young boys are presumed to be innocent indeed. But think about it, ladies and gentlemen. This is what we talked about. And if you're going to do it for one case, I think you then got to start doing it for all the cases. But you could say, oh, Scott, these parents didn't know what these young boys were going to do. Well, do they? Have they been talking about this? Maybe they need to go search the computers, see what kind of parent interaction was taking place. Apparently, somebody raised these two children to think that, after all, it's okay to do this to a 12-year-old girl. And when they're doing it, they're assaulting her to shove rocks in her mouth. Are you kidding me? One could say that was learned behavior. One could say the parents must have taught them that behavior. Maybe we need to go hold the parents accountable. Let me know what you think, ladies and gentlemen. If it's good enough for one type of case, shouldn't it be for all juvenile cases? And this is what I told you. It's a slippery little slope. You want to go down that game? Well, maybe it's just for the cases that, we really feel strongly about. Why shouldn't we feel strongly about a case like this, ladies and gentlemen? Next, the Nancy Guthrie investigation undergoes a significant federal shift. That's right. Some recent developments in the case of Nancy Guthrie, obviously the mother of Today Show host Nancy Savannah Guthrie. Anyway, there have been reports to indicate a potential transfer of primary investigative authority to federal officials more than a month after her presumed abduction from her Tucson, Arizona home. Now, apparently there is obviously the disappearance, and then key evidence is under review, the scaling back of local resources, and the implications of some heightened FBI involvement. Now, for those who don't recall, Nancy Guthrie was last confirmed alive in the early morning hours of February 1st at her home there at the Catalina Foothills neighborhood near Tucson. Her pacemaker's final synchronization with her device occurred about 2:28 a.m., shortly before the surveillance footage from a neighborhood Ring camera captured a vehicle, possibly a Kia Soul, departing the area at approximately 2:36 a.m. A Nest doorbell camera at the Guthrie residence recorded a suspect wearing an Ozark Trail backpack, and police believe that she was abducted. Now, with a ransom demand of some $6 million issued and a deadline of 5 p.m. on February 9th. Now, obviously, nobody believes that those demands, well, I guess some people could, but I don't believe, nor did I ever think that that was a valid demand. Nobody goes to the press for a third-party intermediary in a kidnapping case. Anyway, the Pima County Sheriff's Department initially deployed up to 400 personnel in this effort, and as of late February, officials announced a refocusing on resources, returning many officers to their regular duties while retaining only assigned detectives on the case unless new leads emerge. A spokesperson emphasized that the investigation remains active and will continue until Guthrie is located or all avenues are exhausted, with neighborhood patrols continuing. Now, the federal involvement has intensified significantly. The FBI has directed the public to submit tips directly to their office, relocated their case headquarters to Phoenix, and conducted site visits to the Guthrie residence alongside federal prosecutors. Now, one of the reasons why the feds may be taking it up is that there's a kind of an issue as it relates to interstate movement. Remember, under federal kidnapping statutes, after 24 hours, the feds can basically kick in if you think somebody's been moved over state lines, perhaps. Anyway, a combined reward of $1 million for information leading to the Guthrie location or the arrest remains unclaimed. Now, obviously, this case has also generated thousands of tips, extensive video footage, and DNA evidence still under analysis. No arrests have been made and no suspects have been publicly identified as the investigation enters now its 6th week. And obviously the transition towards greater federal oversight signals a strategic recalibration aimed at resolving one of the year's, most prominent missing persons cases thus far. Next on the docket, federal prosecutors elect not to appeal the ruling barring the death penalty for old Luigi Mangione. In a decisive procedural development, federal authorities have chosen not to appeal a judicial decision that eliminates the possibility of capital punishment in the high-profile case against Luigi Mangione, the 27-year-old accused of assassinating United Healthcare CEO Brian Thompson. Brian Thompson was assassinated when he was shot from behind outside a Midtown Manhattan hotel back on December 4th of 2024 as he approached the United Health Group's annual investor conference. Surveillance captured the masked assailant, and shell casings bore inscriptions referencing insurance industry terminology: delay, deny, and depose. Mangione was arrested 5 days later in Altoona, Pennsylvania, while eating at a McDonald's restaurant. Now, Mangione, a University of Pennsylvania graduate from the prominent Maryland family, has entered pleas of not guilty to both federal and state charges. And in late February of 2026, the U.S. District Judge Margaret Garnett dismissed the federal murder through the use of firearms count, ruling that the accompanying stalking charge did not qualify as a crime of violence under the applicable precedent. The 39-page opinion acknowledged the counterintuitive outcome, but stressed fidelity to Supreme Court directives. The stalking charge, which carries a potential life sentence, remains intact. The reality of it is, ladies and gentlemen, this is a death penalty case in New York. Highly unlikely that you are going to get a death-qualified jury that's actually going to impose the death penalty for a guy that basically has lived a pretty good life, until basically he went wackadoo and thought that the best way to go around with your political agenda was to go around shooting people. Can't do that, ladies and gentlemen. So anyway, it's just a good tactical move. The evidence is pretty strong as it relates that it was Luigi Mangione that did the assassination. Now, we'll give him the presumption of innocence until a jury convicts him, which they will, I do believe, in my humble opinion. But as of right now, it made good sense for the prosecution not to appeal that. Let's get this trial rolling. Let's see what the outcome's going to be. Next on the docket, the daughters of Suzanne Morphew. They file a motion seeking return of their mother's remains. So a new legal filing in the long-running case surrounding the death of Suzanne Morphew is requesting the immediate release of her remains to the next of kin, alleging improper state seizure following the lawful transfer to a funeral home. Now, obviously, we're going to take a look at the motion's content, the procedural history, and the status of Barry Morphew's murder charge. So for those who are not familiar with this case, Suzanne Morphew disappeared on May 10th, Mother's Day, during a bicycle ride near Salida, Colorado. Her remains were later recovered and in April of 2024, lawfully released by the Chaffee County coroners to the designated funeral home for burial arrangements by the next of kin, her daughters, Mallory and Macy Morphew. Now, according to a redacted motion filed in late February, there in the Alamosa County District Court, state authorities subsequently took possession of the remains from the Swan Law funeral directors without prior notice of warning, thereby preventing the planned service. Now, the motion submitted by counsel representing the daughters demanded a full explanation for the seizure and withholding issuance of a temporary restraining order to bar further interference and prompt return of the remains to the family for internment. Now, the Swan Law funeral directors declined comments, citing privacy and ongoing cooperation with police, while the Chaffee County Coroner's Office offered no statement. Now, also, as you may recall, Barry Morphew, charged with the first-degree murder in his wife's death, entered a plea of not guilty back in January. His attorneys likewise have also declined to comment. Now, as of late February, the court has not yet ruled on the filing. The motion is, obviously, there's some tension between the prosecutorial needs and the family's rights in high-profile cold cases that turned into a murder prosecution. So these are always difficult situations, ladies and gentlemen. Now, normally what takes place is the police do their investigation. The body or the remains go to the coroner's office. The coroner's office conducts their autopsy and any other testing, and they do what they need to do. And sometimes they'll say, hey, defense, do you want to take, if there's a defendant at the time, they're going to say, we're going to release the body if you'd like to do so. Take your own independent look at it. Most of the time that doesn't take place. But obviously this particular case, the remains were found several years later, and they were obviously subject to analysis. Now, I can honestly say I've only had this happen to me once, and it was with a double dead baby case over on the western slope. Basically, the children were died they still have no idea why they died. Nobody does. But apparently on the western slope, it doesn't matter if you have a couple of dead children, and the prosecutors can't say how they died, when they died, and who is responsible for it. They just charge everybody and send your client off to prison, even though it wasn't even his children. Real big problem there, but hey, we digress. Anyway, in that particular case, literally the remains were in the coroner's office for years. Ultimately, we had to ship the remains to another pathologist to review them in a different state. We literally FedEx them. Can you believe that? The remains of dead children in a box being FedExed. And then they brought them back. And ultimately, once the case was done and sentencing was over, the prosecution decided to turn the remains back over to the father of the children so that they could have a proper burial. And that was like 3 years later from the time that the children had passed away. So the prosecution is going to say this is part of an investigation, this is evidence, and we want to hold on to it. Obviously, the court's going to have to balance the interest here of the state's rights to do this, keep the evidence until the case has basically gone through trial and any appellate issues and post-conviction if there's a conviction, versus turning over the remains now. We'll see. Somehow I think this judge will say, state, what are you doing? What further evaluation review do you need that you couldn't have done already before you turned them over to the funeral home? I think the kids may win on this one. Next on the docket, the trial commences for that former Louisiana mayor accused of hanging out with her son's friends. That's right. Court proceedings have begun in the Beauregard Parish against Misty Roberts, the former mayor of DeRidder, Louisiana, on charges of third-degree rape and contributing to delinquency of juveniles stemming from an alleged 2024 incident involving a minor. Roberts, 43, resigned as mayor shortly before her arrest, and prosecutors allege that during a late-night pool party at her DeRidder residence in 2024, attended by teenagers who consumed alcohol, she engaged in sexual intercourse with a 16-year-old boy who was a friend of her son. That's taken wanting to be the cool mom to a whole new level, isn't it? Anyway, the gathering included some photos, which is evidence of minors holding drinks. Anyway, testimony has included accounts from Robert's son, who stated in a 2025 forensic interview that he observed the encounter through a crack in a window and texted his mother warning that the youth was underage, describing the situation as crazy, he said. Anyway, her daughter reported seeing the pair on top of each other as well. And Robert's ex-husband, Duncan Clayton, testified that she confessed the incident to him and that their children had witnessed it. Additional evidence encompasses text message, a DoorDash delivery record for emergency contraception ordered under the name associated with Roberts, and photographs depicting Roberts in the proximity of the teenager. Now, Miss Roberts has pled not guilty, and the current proceedings represent obviously the second trial following an earlier mistrial attributed to judicial issues. And as of today, testimony continues with the defense challenging certain interview transcriptions and witnesses' recollection. No verdict obviously has been reached as of yet. Ladies and gentlemen, oh my God, I know, there's always somebody, one of those parents that wants to be the cool mom or dad. No, your job is to be a parent, not the cool mom or dad. Okay? Next thing you know, you're drinking a couple of beers, I guess. Next thing you know, you're sleeping with your son's friends, who's 16, for God's sakes. Unbelievable. And yet this person found their way to convince an entire town to vote for her as mayor. Unbelievable, ladies and gentlemen. Next, another sheriff deputy in some trouble for falsifying some overtime payments. So a veteran officer with the Jacksonville Sheriff's Office has been arrested and charged with multiple felonies after allegedly submitting more than 200 hours of fabricated overtime claims, resulting in the improper receipt of $14,000 in pay. Now, Christian Madsen, a member of the Jacksonville Sheriff's Office for more than 11 years, faces charges of grand theft, organized fraud, and official misconduct. Now, police also allege that over a 3-month period, he claimed overtime pay for hours not worked, including reportedly the time that he spent at a residence of his romantic partner, Patrol Support Division Chief Jamie Eason. Now, the sheriff, a guy by the name of T.K. Waters, announced the charges at a press conference, confirming the personal relationship and noting that Eason resigned following a discussion with him. Waters expressed disappointment in Eason's actions while emphasizing that no evidence indicated her involvement in or approval of the false filings. He underscored department policies requiring immediate notifications of post-employment relationships to mitigate conflicts of interest and reiterate that no individual is above the law. Well, Madsen was arrested, immediately suspended, and released on bond. Each third-degree felony carries a maximum of 5 years in prison and a $5,000 fine. The sheriff's office has initiated an administrative review and affirmed its commitment to transparency and continued cooperation. Don't you love that? It's like schools when their teachers are having, inappropriate relationships. We're going to continue to investigate and ensure that everybody is safe. We turned a blind eye to it or we're completely ignorant of the fact, but that's okay. We're going to now really get serious about it. Next, this day in legal history. Gibson v. Ogden, March 2nd, 1824. So in a unanimous opinion written by then Chief Justice John Marshall, the United States Supreme Court ruled that the Commerce Clause of the Constitution grants Congress broad and exclusive authority to regulate interstate commerce, including navigation of interstate waters. That decision invalidated a New York granted steamboat monopoly that conflicted with federal license. The landmark ruling established that federal supremacy in matters of interstate economic activity, laying foundational precedent for the development of a unified national economy and expansion of congressional regulatory power. Now, going all the way back then, ladies and gentlemen, they said feds are going to do interstate commerce. Can you imagine if each state had their own form for road signs, their own regulations for each and every semi or truck on the road? It would be a complete hodgepodge and it would be a mess. So federal law being supreme to state law, hence the supremacy clause. That's right. No state can pass a law in violation of federal law. It is null and void upon receipt, ladies and gentlemen. And this gives exclusive authority for the federal government to regulate interstate commerce, as so mentioned in the Constitution. One of the, 9 things the federal government was supposed to do. That's it. 9 things. We'll save it for another day, the 9 things they're supposed to do. Next, how about March 2nd, 1867? Congress overrode President Andrew Johnson's veto to pass the first Reconstruction Act, a cornerstone of post-Civil War policy. The legislation divided 10 former Confederate states, excluding Tennessee, into 5 military districts placed under federal oversight, and it required Southern states to draft new constitutions guaranteeing black male suffrage and to ratify the 14th Amendment as a condition for readmission to the Union. This act shifted Reconstruction authority from the executive to Congress, fundamentally reshaping federal-state relations, civil rights protections, and the reintegration of the South into the Union. And on this date, March 2nd, 1917, President Woodrow Wilson signed the Jones-Shafroth Act into law, granting statutory United States citizenship to inhabitants of Puerto Rico. The statute also established a Bill of Rights for the territory, restructured its government with an elected bicameral legislature, and created clear executive, legislative, and judicial branches. The legislation altered the legal and political relationship between the United States and its unincorporated territory, creating the framework of statutory citizenship that constitutes to define Puerto Rico's constitutional status today. Our legal quote of the day has to do with arguing before the United States Supreme Court. All right. And when you listen to this, think about this, ladies and gentlemen. This applies to just about everything in life. Okay. Now, this comes from an article called Advocacy Before the United States Supreme Court. And Justice Jackson remarked, quote, "I used to say that as Solicitor General, I made 3 arguments of every case. First came the one that I planned, as I thought, logical, coherent, complete. Second was the one that actually presented, interrupted, incoherent, disjointed, disappointing. The third was the utterly devastating argument that I thought of after going to bed that night," end quote. So this reflection remains a commonality among not only appellate practitioners, but anybody has to go in front of a court to make an argument. And it illustrates the pressures of not only here the Supreme Court argument, that the carefully prepared versions, the interrupted reality under rigorous questioning from the justices, and the perfect rebuttal realized only in retrospect. Gee, I've never had that happen before. Seriously, ladies and gentlemen, you can go in, you have your argument made. I don't care what it is, whether it's a motions hearing or what, and something changes. But that's the beautiful thing about the practice of law. It's like what they teach you when you go into the military. No matter how well you have planned it, that beautifully planned operation that you have goes out the window once the first shot is fired. And in the courtroom, no shots fired, figuratively only. But once that first question is asked, it all changes. Next, our dumb criminal of the day. An ex-con jailed after using his McDonald's frozen food coffee as a weapon. More food crime, ladies and gentlemen. Now, in a blend of questionable judgment and frozen dairy, a 29-year-old Florida man was found himself back behind bars after allegedly transforming a McDonald's frap into an instrument of assault during a late-night drive-thru encounter. According to police reports, the incident unfolded around 1 a.m. on January 31st at a McDonald's restaurant in Seminole. Daniel Abramowitz, while positioned in the drive-thru lane, engaged a brief discussion with a 28-year-old employee. Police allege that the conversation ended abruptly when he hurled the blended frozen coffee beverage directly at the McDonald's worker. The frap struck the victim in the face, causing the container to burst open on impact and drench her face, hair, and jacket in its sticky contents. Of course, there were surveillance cameras that captured the entire episode, enabling the employees to positively identify Mr. Abramowitz as the perpetrator. The charge of battery has been elevated to a felony because Abramowitz's prior conviction for domestic battery, in which he punched the mother of his child in the face. He is also accused of violating a 3-year probation imposed following a 2023 felony conviction for stealing and pawning a watch. Anyway, a native of New Jersey, now residing in Florida, Abramowitz maintains an extensive criminal history that includes convictions for burglary, obstruction of justice, and multiple probation violations. He has previously served several jail sentences. Now, this little development placed him firmly back on ice, serving as a frosty reminder that some customer service interactions are far safer resolved with words rather than beverages. Anyway, Abramowitz remains in custody as his proceedings continue. Mr. Abramowitz, our dumb criminal of the day. Just let it go, by God. Let it go. All right, ladies and gentlemen, that's all we have for you today. Happy first week of March. We'll see you tomorrow. And always remember, the Constitution matters.